That rule was enshrined in the 14th Amendment.
Non-citizens can.
Sacramento homeowners are
that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you, counsel. Ms. Wong?
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen alike. That rule was enshrined in the 14th Amendment to put it out of the reach of any government official to destroy. When the government tried to strip.
Let's take a poll on that. How many actually what you would consider to be American people made that statement? Yeah, let's take a poll on that. And if it was so overwhelming, is that the actual truth? Or is it from what people have been told and what they rely on? Think about that.
Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on U.S. soil is subject to its jurisdiction and is a citizen. It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction.
Okay, so this is her opening argument. So she's saying anybody born on U.S. soil. All right, so U.S., that's a misnomer because it's not the U.S., it's the United States of America. And U.S. can stand for anything. You're coming into Supreme Court. So you know that when you come in, when you appeal the inferior courts, right? Because under Article 3, in all matters dealing in Constitution, Admiralty, whatever, I'm paraphrasing, that the Supreme Court has original jurisdiction. Original. But they created these lesser courts or these inferior courts in the state and Supreme Courts in the states in order to expand a little bit so that way the Supreme Court wouldn't be flooded, because if that was the case, everybody would come straight to the Supreme Court with their claim. So in order to do that, they set up these inferior courts. You have, let's say, for instance, California, you have a superior court in every county. And then you have your appellate court in the state. You also, in the state, you have your district courts that are considered to be the federal courts that are governed under the statutes, codes, and the Constitution that deals with admiralty, bankruptcy, and constitutional questions. But most of the time when you get to the appellate court deals with a constitutional question. It also deals with the fact of if the judge / court / jury trial court made any type of errors in their judgment. One of the main things is if the entity, individual per se, rights, constitutional protected rights were violated, i.e. due process, equal protection under the law, or if the ruling of all these things, be it civil, are in conflict with the Constitution. So usually when you come into an appellate court, you're really raising a constitutional question. So this is your basis of everything. But what she just mentioned is U.S. soil. So U.S. soil is what you consider to be just solely of right of soil, right? And we had talked about that yesterday. But she's already opened up with a misrepresented fact of what she's trying to say in order to make her point. This is what a lot of these people do when you abbreviate. If you abbreviate based off of a claim that you're making in order to kind of veer off into a jurisdiction that's a fiction. So you got a fiction jurisdiction. And then once those things are ruled upon, then that language is kind of, I wouldn't say set in stone, but then it becomes full faith and credit. So let's just go back. Let's get to, boom, right there.
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen alike. That rule was enshrined in the 14th Amendment to put it out of the reach of any government official to destroy. When the government tried to strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on US soil is subject to its jurisdiction and is a citizen. It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly said that
See, she used the word territoriality. Territoriality. Is that a word or is that an ideal? It can be kind of idealistic in territoriality. So it's like virtuality or ITY being a suffix at the end of virtual. So you got territorial. And then you got the ITY, territoriality. What does that mean? See, everything that she's saying is all based in some fictional talk that has no standing. And she is saying, well, it's already here. We got to rely on this. See, there you go with the word rely.
government is not asking you to overrule Wong Kim Ark. That is a fatal concession because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch versus Clark was already the dominant American case on citizenship, and it held that the US-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a US citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being US citizens. Justice Field said in 1884 that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed, bright-line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable, and it prevents manipulation. The executive order fails on all those counts. Swaths of American laws would be rendered senseless. Thousands of American babies will immediately lose their citizenship. And if you credit the government's theory, the citizenship of millions of Americans, past, present, and future, could be called into question. All of this tells us the government's theory is wrong. I welcome the court's questions.
Now, what she said at the end is pulling on heartstrings. She said thousands of American babies will lose their right. But if they do not fall under birthright citizenship, I would say policy, not really law, but policy, then they're not Americans. And you know what the crazy thing for me is that these people, when they want to cry foul, when it benefits them, but the actual majority group here gets no conversation. As we've been seeing over these last 3 days, what you're hearing is who is not involved in this conversation? Who hasn't been mentioned? Technically, who hasn't been mentioned? Now, we could say about the Indian and all that, so on and so forth, but let's just say for the majority of the people are not really worried about that. They're really hanging their hat on Black, African American, right? They're hanging their hat on Black or Black American or African American or foundational Black American. You know, they're hanging their hats on these titles, but it has not been addressed not one time. So only two entities that had been really discussed. That's children of slaves and Indians, not taxed. Those are the two entities that have been discussed in this argument. Nothing else.
There are 5 exceptions to citizenship that you do accept.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the underlying rule of law?
Fact. Right. Right. Yeah. A lot of people don't know that. A lot of people think that the whole world is like America. It's not. These other countries don't tolerate none of that. Like all this stuff that's tolerated here, that goes on here, doesn't happen anywhere else. For the most part, they're not having this question. People ain't just coming up in there just doing things. Like these people that have came up in here has been documented as spies that have came in, have gotten A1 credit, free education to learn the whole entire system, to sit up under people, to get intelligence, to do all these things on the so-called taxpayer dime. But for some reason, this attorney is so adamant about children about to be moved out of here. But at no point in time, they're talking about the West African slave trade, the transatlantic slave trade, the triangular slave trade, and all this. They haven't mentioned it not one time. Outside of African potentate. And we looked up what a potentate is. It's an emperor. That's a king. That's a ruler.
that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States because that extraterritoriality, that fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend, that's what sets those exceptions apart from other US-born persons.
We've heard a lot of talk about Wong Kim Ark, and you dismiss the use of the word domicile in it. It appears in the opinion 20 different times, and including in the question presented and in the actual legal holding. And the government doesn't want it to be overruled because it's willing to rely on that particular fact in that case. Isn't it at least something to be concerned about, to say that since it's discussed 20 different times and has that significant role in the opinion, that you can just dismiss it as irrelevant?
Well, Mr. Chief Justice, I think we have to look at what the controlling rule of decision is in Wong Kim Ark. Justice Gray takes pains in the majority opinion to set out his analysis. He first starts with a premise that in construing the 14th Amendment Citizenship Clause, we look to the English common law. That was the rule that applied from the colonial era on, at least for the colonists and for European immigrants. He then says, look, Chief Justice Marshall tells us in the Schooner Exchange what subject to the jurisdiction means. Again, looking to the English common law. Under English common law, if you are born in the dominions of the sovereign, you owe natural allegiance. And those who are present in the dominions of the sovereign owe temporary allegiance for as long as they're present. The only exceptions, again, at common law were ambassadors, people born on foreign ships, and people who were born during periods of foreign occupation. He then gets to the government's favorite page, 693, where he says, look, we have had
Foreign occupation. So when you have a bunch of people coming over here being born, and these are foreign nationals, meaning they have allegiance to another sovereign, and they're in foreign territory like America, wouldn't that be considered to be a form of foreign occupation? What she's trying to push in her argument that it doesn't matter. They're born here. So that means they're U.S. citizens, Americans. Which one is it? She's saying American in one sentence, then she's saying U.S. citizens in another sentence. She's changing it, but at no point in time, she's really stressing the United States. She's going back to English common law, but she's dancing around the topic. What's really birthright citizenship? She hasn't done that yet.
this rule in the United States as to citizenship, at least for white Americans, from before independence. The purpose of the 14th Amendment was to embrace that universal rule of birthright citizenship, to embrace and incorporate the common law exceptions with the single additional exception of the pre-existing exception for tribal Indians that we had in the United States, which is an analogous exception, and that's the closed set of exceptions. You can't make sense of the holding in the case without looking to the controlling rule of decision, which is the common law. And I think my friend agrees that under English common law, domicile was not relevant, and the children born to temporary visitors in the territory of the sovereign were always considered birthright citizens.
Well, Ms. Wong, I mean, everything you say strikes me as, yeah, that's the way I read it too. But then what are those 20 domicile words doing there? Like you can, take some of them and say, they were just summarizing the facts of the case, but not all of them. And why did they keep on, why did they sprinkle that in the opinion?
Well, I think, again, those were the stipulated facts in the case. And it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions, with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph, he cites to Webster talking about Thrasher's case. And he says, people who are born in this country owe allegiance independently of a residence within, foreign nationals owe allegiance independently of a residence with intention to continue such residence, independently of any domiciliation, and independently of taking any oath of allegiance, which is totally contrary to both the government's theory of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I might agree with you if
Domiciliation. There should go with the Asians and the what is that? See, all that is ideal talk, ideology talk, fictional talk, floating out there. It stands on nothing. She's trying to try to knock the whole thing down like it hasn't been thought out and put in place, and it holds weight. It's concrete. She's manipulating the language, and this is what they do. This is what attorneys do in order to make a point. In order to make a point on their behalf, they will take the language and turn it upside down. And this has been the problem with the legalese conversation. You can actually take a word and pretty much separate it and turn it somewhere else where it ain't supposed to be and create a whole virtual reality on it.
had simply been sprinkled in the opinion. But in Wong Kim Ark, it's a long opinion, but it begins by saying, here's the question, and it ends by coming back to the question. And it says, here's the question stated at the beginning of the opinion, namely whether a child born in the United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business, and he states the diplomatic exception, and he says, for the reasons above stated, this court is of the opinion that the question must be answered in the affirmative. So why put domicile in? Sometimes it's hard to figure out what is the holding of the case. Here he tells us this is the holding of the case. Why put domicile in there? It's just something, it's something irrelevant that he wanted to throw in. It's like, whether a child born in the United States of parents of Chinese descent who once resided at a particular address in San Francisco, who attempted to enter the country at the port of San Francisco.
Now, just know, this whole argument that's being created by ACLU is they're using a so-called Asian guy. Well, they're using a case that involved an Asian guy. This is not even involving Mexican people. This is involving an Asian. Everybody has been, let me save all this for my conclusion. Let me just let it ride.
Why put it in if it's irrelevant?
Well, Justice Alito, I'll give you two responses. The first is that, again, it was a stipulated fact. The second is that regardless of what the judgment in the case was, which again was an a fortiori application of the rule of decision, the rule of decision in Wong Kim Ark has binding precedential effect. Even if you think that Wong Kim Ark decided the case based on the stipulated facts, you have to follow that controlling rule of decision. And if you follow that rule, you get to the same result for people without domicile. Wong Kim Ark says 6 times in the first parts of the opinion, as well as on the page the government focuses on, that domicile is not relevant.
Well,
That
Ms. Wong, on that, what do we do with the fact that after Wong Kim Ark, at least some authorities took the view that the non-domiciliary question wasn't decided, remained open, and even continued to press the view that domicile is required? Now, I know you've got a lot of good stuff on your side too, but what do we do with the fact that many sound legal authorities thought it remained an open question, even if one of them wasn't John Marshall Harlan?
I liked your example from Justice Harlan's lecture here in DC. So here's what I would say. All of the government's citations in their brief generally either were rejected by Wong Kim Ark expressly if they
I'm talking
predated Wong Kim Ark.
post. If we're trying to understand how the legal community understood what happened in Wong Kim Ark,
Sure.
it seems to me it's a mess.
So
Maybe you can persuade me otherwise.
I think I can, Justice Gorsuch. First, as to the post-Wong Kim Ark authorities that the government cites, each one of them is inconsistent with Wong Kim Ark's reasoning or doesn't mention it at all. Most of them have very little reasoning at all. And in contrast, what we have on our side post-Wong Kim Ark is numerous federal court decisions around the time of Wong Kim Ark, between ratification and Wong Kim Ark, that said that domicile is not relevant. They cited Lynch versus Clark, which again was about the daughter of temporary sojourners. We have the 6th edition of Kent, which was cited in Wong Kim Ark, and of course was then cited after Wong Kim Ark was decided by many authorities, again, discussing temporary sojourners. Anyone who wanted to know what the law of citizenship was under the 14th Amendment after Wong Kim Ark would go to the 6th edition of Kent, where he says in that footnote on page 38, that the rule was Lynch versus Clark, and temporary sojourners' children are US citizens. We have members of Congress speaking on the record on debates on immigration laws, where they were finally passing these immigration restrictions that Senator Cowan wanted. And they all stated either that Lynch was the rule, that Attorney General Bates had stated the rule, again, citing Lynch, or Kent, and stating the rule that everyone born in the US is a citizen, and saying, look, children of Chinese immigrants, these immigrants who are unwelcome, these immigrants that Congress is now trying to bar from entering the United States, if their children.
Where's the violin? You see who she's focused on? That's who she's focused on. She's focusing on that. And if that's her only case, if that's the only thing she has to stand on, you lose. Because the popular narrative is there's all these other things going on. So, yeah.
Children born in the United States are citizens. We have an 1896, so a couple years before Wong Kim Ark, but an 1896 State Department regulation, which said the US-born children of foreign nationals are US citizens, accepting only the children of ambassadors. And then you have Marshall Woodworth, who is a US attorney who writes in a law review article that he's talking specifically about temporary sojourners' children, and he says, I don't think that's a good rule from a policy perspective, but that's the general rule.
Ms. Wang, can I?
Yes.
Remember I said policy, right? This is just policy. It has nothing to do with the Constitution, the rule of law. They're talking about policy. Now, she says U.S. born citizens, right? She keeps using U.S. There's no such thing as U.S. It's the United States. It is United States, not U.S. See, that's where you get into your assumptions and presumptions. She also mentioned earlier about stipulated facts. A stipulated fact is something that someone believes to be a fact. But an unrebutted fact or truth is considered to be correct. If you don't rebut it, you agree. It falls along the line of what you consider to be prima facie evidence. But those facts, that evidence could be misrepresented as something that is not. But if you do not respond or rebut that, it then becomes the truth by default. It still doesn't make it a fact. It just means it hasn't been rebutted yet. This is where you get into abandoned lands and people say, oh, it's abandoned, suspect classifications, where people still on their land being misclassified, reclassified, or put into a suspect classification without them knowing. There's no opportunity to rebut it. Then it's still like being served in a name that is not familiar to you, or being served at a location where you're not, and they take that to the court and say, hey, I did all the administrative procedure, I exhausted everything, I need summary judgment. And they get it.
Can I offer a possible explanation for why Justice Gray made a point of putting domicile in what he said was the holding of the case? And it is this. Wong Kim Ark and his parents, had they come to the United States from Europe, could have been naturalized, but because they were Chinese, they could not be naturalized. And they had done everything that they could to make themselves Americans by establishing a domicile in the United States. And so that's what this was about. He couldn't get naturalized because of a racist law, but they had done everything they could to become part of the American society. At the same time, there were many, many men who were horribly exploited, brought to the United States to work on the Transcontinental Railroad, to work in mines. They were worked to death. They were treated horrifically, but they were not. They were overwhelmingly men. There wasn't an indication that they would stay here. They could stay here. They didn't have permanent homes. And the opinion is drawing a distinction between those two categories of people who would have been well understood at the time when Wong Kim Ark was decided.
No, Justice Alito, I don't think that's a plausible explanation for why domicile is mentioned in Wong Kim Ark, because again, the controlling rule of decision based on the English common law and cases from Schooner Exchange to Lynch versus Clark to State versus Manuel, which was the North Carolina decision that said, look, the rule in the United States from independence on has been the English common law rule.
That's what I've been saying, business. They're not talking about anybody else. He just started mentioning the Irish. This whole conversation has been about an Asian guy. This Wong Kim case. And she's using that as her foundation of her argument. Why birthright citizenship should pertain to millions of people being brought over here. Right? Children, though. Children brought over here. Children brought over here by parents. But having allegiance and being foreign nationals somewhere else. But what she's saying is that the United States government in their ambiguous language, has not really substantiated what is birthright citizenship. And this has been an open wave or open door for people to just come over here and have children, set up shop, be able to get benefits and privileges and all the things that come with the United States of America and America citizenship itself, at being really more of an American national. You can only be one national. If you are a citizen, then you're in a different category. But she's not mentioning anything about what the conversation is supposed to be about. What everybody got the whole hoopla about. What's been the whole entire argument? The whole entire argument has been dealing with Black people and slavery and African slavery, right? 400-500 years of it. Last time I checked. I could be wrong. Who knows? Who knows?
That explanation would be inconsistent if.
But Ms. Wong,
yes.
isn't that explanation, I take Justice Alito's point, and I think he actually makes a good one in the sense that it could be that Justice Gray emphasized domicile to help the public accept the outcome of this case. You're suggesting that the emphasis on domicile was not a part of the rule, meaning he wasn't saying you had to be like a foreigner who is doing everything they can and who can't be naturalized, but he might have emphasized those facts in this case precisely because Chinese immigrants were unwanted, precisely because he had to get this out into the public and people were going to say, whoa, you're saying these people have to, this baby has to be a citizen? And so one could imagine that it was important from a standpoint of helping people accept this citizen rule under these circumstances to emphasize that these particular people in this case were in Justice Alito's first category.
I think that is very possible, Justice Jackson. And as evidence of that, I would point to the fact that if you look at the briefing in Wong Kim Ark, you'll see that even though the parties had stipulated in the district court that Wong Kim Ark's parents were domiciled in the United States, when the case came to the Supreme Court, the government's brief argued that it was impossible for Chinese immigrants to have domicile because they expressed the view that was common among people who opposed immigration by Chinese nationals to the United States. There was a common view that Chinese people were inherently temporary sojourners in the country. And so I do think it's possible, Justice Alito and Justice Jackson, that he was trying to dispel that notion and tell the government.
Absolutely, that at least it reads as though he's trying to calm everyone down. These particular people were domiciled, but we're following the English common law rule. And when you look at the English common law rule, domicile is not a factor.
That's right. I think, you know, who knows why the majority opinion mentioned domicile. We know is a stipulated fact. We know the government tried to renege on that stipulation and rely on this assumption on the part of anti-Chinese advocates at that time that Chinese people couldn't form a domicile in the United States, and he followed the English common law rule.
Ms. White,
Counsel-
can I move?
Go ahead.
I just wanted to ask you a question about how the exceptions fit within the general rule. You've called them exceptions, and some of the common law sources call them exceptions, so I take that point. But if we think of use solely as tied to the territory, and we look at the exceptions as territorial in a sense, then they seem kind of like natural outgrowths of that rule, and this is what I mean, and this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as unique places because Indians were quasi-sovereign, separate nations in the American system. If you look at occupied alien territory as territory that's outside the jurisdiction.
Okay, so Justice Amy Coleman Barrett just stated that in dealing with Indians, she said quasi sovereign. All right, but the sovereign is there, but quasi sovereign. She made a point. Let's see where this goes.
Jurisdiction of the United States. And then if you look at the diplomatic exception, and this is what I mean, and this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as unique places because Indians were quasi-sovereigns, separate nations in the American system. If you look at occupied alien territory as territory that's outside the jurisdiction of the United States. And then if you look at the diplomatic exception, almost like diplomats and their children had little bubbles around them, like the embassy is really the territory of that country. And even when they're traveling around, they're all not subject to the jurisdiction by virtue of this territorial fiction. Are those just applications of the rule? And if they are, then what happens to alien enemies like the German spies in Ex parte Quirin, or what happens to Indians who are actually not on the reservation but may be born, say, in Baton Rouge? How does the rule apply in those situations? Does it travel with the person, or is it tied in some sense to the land?
Sure. So let me answer each part in turn. So,
Ooh, that's a question. That's a question right there. That's a good one. That's a good one. I'm gonna go ahead and let's run it back because that's a good question. Does it travel with them, or does it just tie to the land? It's a good question. Let's run it back.
On them, like the embassy is really the territory of that country, and even when they're quasi-sovereigns, separate nations. And this is what I mean, and this is where I want.
People couldn't form a domicile in the United States, and he followed the English common law rule.
Ms. Mike,
Counsel-
can I move?
Go ahead.
I just wanted to ask you a question about how the exceptions fit within the general rule. You've called them exceptions, and some of the common law sources call them exceptions, so I take that point. But if we think of use solely as tied to the territory, and we look at the exceptions as territorial in a sense, then they seem kind of like natural outgrowths of that rule. And this is what I mean, and this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as unique places because Indians were quasi-sovereigns, separate nations in the American system. If you look at occupied alien territory.
All right, check. We'll look up what quasi means.
As territory that's outside the jurisdiction of the United States. And then if you look.
So she's also saying that's outside the jurisdiction of the United States. I think I pretty much kind of hammered that home, but we'll just reiterate that.
Look at the diplomatic exception, almost like diplomats and their children had little bubbles around them, like the embassy is really the territory of that country. And even.
Okay, so the embassy is the territory of that country. So, for instance, all of these embassies, all of these countries have embassies in the United States. They have a place where they go, where foreign nationals come through, whatever the way it's supposed to go. And to get their protection, because they're not here as United States citizens, they might be here on an H-1B visa or some type of I-9 or whatever, these different type of visas where they're just here temporarily. You know, like they bring them over here. You see a lot of people in college sports, you know, coming from other countries. More importantly, you see more of it in basketball, where you got these foreigners coming over here on I-9 visas, coming over here to play ball, sports, but they still have foreign national status. They're not United States citizens. One guy, for instance, the guy that played the Turk that played for the Celtics, Cantor, Enes Kanter. He talked against his country and Turkey and stuff like that. And he was here under protection. And then eventually and I think in 2021 or something like that, during the previous administration or at the end of Trump's administration into the second administration of, the first administration of Biden, he became a United States citizen, but he played at Kentucky, played at the University of Kentucky, hooped there, played in the league for a good minute, played hoop, played in college, but at no point in time, he was considered to be a United States citizen. He showed it. He talked about it. See what I'm saying? Then come to find out that his parents were more like diplomats out there. There were some major players out there. See? He's a good example. Don't be sleeping on the sports. You find a lot of good information on sports. It's not just about the ball. It's got a whole lot more to it. A lot of politics in sports, a lot of it.
When they're traveling around, they're all not subject to the jurisdiction by virtue of this territorial fiction. Are those just applications of the rule? And if they are, then what happens to alien enemies like the German spies and ex parte Quirin, or what?
And we're going to talk about alien enemies, right? There's an Alien Enemies Act, 1789, that happened right before you had the Naturalization Act.
Happens to Indians who are actually not on the reservation, but maybe born, say, in Baton Rouge? How does the rule apply in those situations? Does it travel with?
I mean, the people that are considered to be Native Americans, who they like to give the whole Indian status to, anybody in Baton Rouge see them out there? You see anybody like that out there?
The person, or is it tied in some sense to the land?
Sure. So let me answer each part in turn. So the thing that all of the exceptions have in common, again, is this sense that the person has this fiction of extraterritoriality around them. Let's set aside the Indian tribal exception for a moment and come back to it. So the example of enemy aliens, for example, ex parte Quirin, is one that is answered by Justice Story in both Inglis and in Rice. And the touchstone under the American application of English common law was that in wartime, the touchstone is whether there's a foreign occupation of US territory. So,
and that's just to interrupt for 1 second to
Sure.
clarify, and that is territorial. Sometimes it just seemed to me that the rule varied. Sometimes it was stated as enemy alien, and sometimes it was focused on occupied territory.
Sure. So the rule, I don't think there's a separate rule for enemy aliens, and the government's briefs describe the exception as an enemy alien exception. I don't think that is the best way to think about it. Rice and English tell you that when the British forces are occupying Castile, Maine, no one is subject to US jurisdiction there because Britain is governing Castile, Maine. And Justice Story explains, look, if the US then retakes that territory, babies who are born to US citizens by what he calls post limine become US citizens. So that's the way to think about any wartime situation, enemy aliens or otherwise. As we heard earlier, Professor Muller's amicus brief tells us how we've thought about enemy aliens in wartime. Even in World War II, when the United States was detaining Japanese nationals who were deemed enemy aliens of the United States, when those enemy aliens had babies in these detention camps, everyone agreed that those babies were US citizens. And Professor Muller goes on to explain that there are many cases of those US citizens going on to a lifetime of government service to the United States. Everyone agrees those babies are US citizens like everyone else. So
now she jumps to the Japanese. At no point in time, the main people of topic dealing with birthright citizenship, naturalization, 14th Amendment, slavery is not being addressed. She dealt with a case that deals with one Kim, and Kim basically is Korean. If you got a Kim on it, you're Korean. And then she jumps to Japanese people. But then she's saying that she references a professor at a university or something. What credibility does he have? He's given his educational opinion of how he's interpreting what was going on at that time. But nobody can call him. Can you bring him forward and ask him what was his thought on that? No, because he's not a primary source. He doesn't have firsthand knowledge of anything. All he's doing is going off of what is being talked about in the public, people's opinion. I'm going to do a survey. I want to know. I want to poll. I want to see what you think. So you got public opinion, popular narrative, but is it the rule of law? Is that what the framers came out and agreed upon? Is this what Congress wrote a bill upon and added to the Bill of Rights on the 13th, 14th Amendment? Is it? She hasn't mentioned it not one time. All she's talking about is this case, this professor, what it said and what she is interpreting it to say, and she's trying to get them to side with her based on individuals that has nothing to do with the 13th and 14th Amendment because they didn't start coming over here to after the 1890s.
Again, the touchstone for enemy aliens is.
So
is
what
there an
about
occupation?
Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins.
The Indian tribal exception. Let's see where this goes. Let's see what this is talking about. Indian tribal exception.
Tells us comes from the constitutionally unique status of Indian tribes. And the Indian Commerce Clause is governing Castine, Maine. And Justice Story explains, look, if the U.S. wartime situation, enemy aliens or otherwise, as we heard earlier, Professor Muller's amicus of the United States, when those enemy aliens had babies in the United States, everyone agrees those babies are U.S. citizens like everyone else. So again, the touchstone for enemy aliens is.
So what about Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins tells us, comes from the constitutionally unique status of Indian tribes. In the Indian Commerce Clause, we know that tribes are treated as basically quasi-sovereign nations. We know that from the Marshall Trilogy of cases. We know from Worcester versus Georgia, where Chief Justice Marshall said that the tribes are essentially a distinct political community.
Well, I understand all that. So just.
She said, well, I understand all that. Yeah, we don't need to talk about any of that. Yeah. She wanted to cut that off real quick. Yeah, a distinct. Yeah, you understand all that, but we don't. We won't hear it again.
Clause. We know that tribes are treated as basically quasi-sovereign nations. We know that from the Marshall Trilogy of cases. We know from Worcester versus Georgia, where Chief Justice Marshall said enemy aliens
So
is
what
there
about
an occupation?
Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins tells us, comes from the constitutionally unique status of Indian tribes. In the Indian Commerce Clause.
Did anybody see my debate? I'm gonna put the debate back up there. I'm gonna put my side up there. It's what I said. The Indian Commerce, the Article 1, Section 8 of the Constitution is the Indian Commerce Clause. Distinct, right? So listen to this closely to all you Indians, of whatever shade or whatever you are. If you call yourself an Indian, right? If you consider yourself to be a Black Indian, a Black American, a Native American, a Black Indian, an Indian, American Indian, whatever you want to consider yourself as. And also, if you're on the other side and you consider yourself an American descendant of a slave, a foundational Black American, an African American, and at one point in time, you use the word nigger, Black. Listen to this closely. At no point in time, you have been mentioned on the other side. The ADOS, FBA audit, you haven't been mentioned yet. But what has been mentioned multiple times, and every single justice has addressed this at one point in time by both sides, the Solicitor General and this young woman right here from ACLU. So I'm going to rewind it one more again.
That, there are many cases of those U.S. citizens going on to a lifetime of government service to the United States. Everyone agrees those babies are U.S. citizens like everyone else. So again, the touchstone for enemy aliens is.
So what about Indians? What about?
All right, here we go. What about Indians? What about Indians?
The Indian who's off the reservation or born off of a reservation?
Sure. So to start.
So if you're thinking about this in this form or fashion, claiming American Indian and, you've been knowing yourself or being classified or you being looked at as Black, African-American, Negro, colored, look at it from this perspective. You pretty much where you're at, unless you pretty much know your family's pretty much been there from the time can't remember. That's all you know. You can actually trace yourself back at least 4 generations in one location. That's pretty good and substantial enough for me, depending on the age. If you're in my age bracket, you want to at least be able to go back at least 6 generations. That's where you'll have your good foundation. But just think of it. You're not in your tribal land, or we would say your land of your forefathers and foremothers. You're somewhere else. They use the term reservation for their own colorable reasons, right? Reservation is more or less for the United States to claim through their preliminary doctrine and their trust doctrine to have some sort of authority or custodialship in these areas. But you're not there now. You're somewhere else. You're in a whole nother state or a whole nother territory, You would be considered to be off the reservation. Because that's where the land is. That's where all the documents that you see, where the money was made and all the so on and so forth, paperwork is there. So think about it like that. Just apply it like that. Don't run from reservation. Just think of it as something that is being used as a term to just call your ancestral land, or the land of your forefathers and foremothers, at least 4 to 6 generations back. All right.
Start with the basics. I'll refer to the Indian tribal exception, just to use the term of art. The Indian tribal exception, Elk versus Wilkins, tells us.
Okay, so that's Elk versus Wilkins, if I heard that correctly. Elk versus Wilkins. All right, so that's what that is. Let's pull up Elk v. Wilkins. I'm making a note. Okay, this is 1884. All right, now we can continue.
Comes from the constitutionally unique status of
Okay, so this is constitutionally unique.
Indian tribes. In the Indian Commerce Clause,
Indian Commerce Clause.
we know that tribes are treated as basically quasi-sovereign nations. We know that from
Quasi-sovereign nations.
the Marshall Trilogy of cases. We know from
The Marshall Trilogy of Nations. All right, let's get that one. Marshall Trilogy of Nations. All right. All right, let's continue. I'm taking notes too. All right, we doing this together. I'm taking notes.
versus Georgia, where Chief Justice Marshall said that the tribes are essentially a distinct political community.
Well, I understand all.
A distinct political community. See, she cut her off right there. We don't need to hear all that. Damn it, people are listening.
So just
Sure.
an entrance of time, just to
Sorry.
focus you. How I understand why the Indians are treated differently for purposes of the law, but I want to know, is it
Why Indians are treated differently in terms of the purposes of the law? That's a good question to ask. Why are the Indians treated differently in terms of the purposes of the law? And what law is that?
tied to territory, or is it tied to the status of someone as a member of a tribe? Because if you're looking at it because of the special relationship of Indians to the United States as a matter of the Constitution, et cetera, well, I mean, citizens of France are citizens of a different sovereign as well.
Sure. So Elk versus Wilkins doesn't really answer that question. The court says there are two ways to look at this. Either you look at it as the tribal member is like an ambassador, or you can look at it like there's.
Say you can look at it as a tribal Indian being like an ambassador. Wow. An ambassador. What timestamp are we on here? 131:10. Let me go back a little bit. I need to get this case.
Currently for purposes of the law, but I want to know, is it tied to territory, or is it tied to the status of someone as a member of a tribe? Because if you're looking at it because of the special relationship of Indians to the United States as a matter of the Constitution, et cetera, well, I mean, citizens of France are citizens of a different sovereign as well.
Sure. So Elk versus Wilkins doesn't really answer that question. The court says there are two ways to look at this. Either you look at it as the tribal member is like an ambassador, or you can look at it like there's a territoriality issue where people are born on tribal lands, and therefore they're essentially, I think he says, Justice Gray says at one point, we might as well be talking about someone who's born in Mexico.
Well, there's a lot in Elk.
All right, so what she's saying is if you're an Indian, right, tribal Indian, on the reservation or off the reservation, she's saying it's like you're being born, like you're born in Mexico. I don't know why she used Mexico, but what she's saying is don't matter. It travels with you. Wherever you go, it travels with you. Based on the occupation of the United States, it travels with you. Interesting. Interesting. So within the United States is still not within the United States, whether you believe it or not. That's what it's kind of boiling down to. Now you see they're taking a lot of time in analyzing this. They're taking a lot of time in analyzing this here. Just like they took a lot of time in analyzing that Kim case, and they took a lot of time in analyzing what is considered to be birthright citizenship for children, right? Children of slaves. 14th Amendment, 13th, 14th Amendment. That's what it was supposed to be for. It was supposed to free slaves.
And some of it's not terribly helpful for you, it seems to me, because Justice Gray, again, strikes again, says that they may be subject in some degree or respect to the United States. So there's some jurisdiction. He says they're born in the geographic limits. They are in a geographical sense born in the United States. But because they are not completely subject to the jurisdiction of the United States and owe allegiance distinct from the United States, that's what takes them outside. And that language sure sounds a lot like the Solicitor General's presentation today.
To the contrary, Justice Gorsuch, I embrace that part of Elk versus Wilkins' holding. Justice Gray, of course, wrote both Wong Kim Ark.
I know, and it's a struggle.
Sure. Let me try to help you out with that. You know, the government tries to make it seem as though what sets the exceptions apart, what defines the exceptions, is that the government has some maximum theoretical power. The government could have exercised plenary regulatory power over the tribes, and therefore that's the same situation as a foreign national in the United States. But that's actually not true, because remember, if there's always this background notion, whatever the parameters of the relationship between the United States government and tribal nations at that time of ratification, there was this constitutionally distinct status of the tribes and tribal members, setting them, excluding from apportionment, which was renewed in the 14th Amendment. And that's not true for nationals. If the government were right, that the question is what's the maximum theoretical power the government has, there would be no ambassador exception, because of course the United States could decide in some instance to go ahead and prosecute an ambassador. There would be inter-sovereign comity considerations there. That's how you define the exceptions. And as Wong Kim Ark says, Elk versus Wilkins has no bearing on the question of foreign nationals.
Ms. Wang, on the earlier answer you gave to Justice Gorsuch on the temporary sojourners cases, those were distinct cases, correct, where the parents had come to the US and didn't want to give citizenship to their kids, took them out immediately, correct?
I'm sorry, Justice Sotomayor, I'm not sure which cases you're referring to.
All right, that we can look at.
Okay.
Ms. Wang, would you agree that the citizenship test in the 14th Amendment is the same as the test in the 1866 Civil Rights Act?
So the words are obviously different. What Wong Kim Ark tells us and what the debates tell us is that the framers, it was the same Congress obviously framing both. Congress was trying to do the same thing with both the 1866 Act and with the 14th Amendment. They wanted to capture the common law exceptions and the Indian tribal exception. They started out with the two separate phrases, not subject to any foreign power, plus excluding Indians not taxed. And as Justice Gray described it in his majority opinion in Wong Kim Ark, they decided to switch to the affirmative phrase, subject to the jurisdiction.
Yeah, well, do they mean the same thing? And wouldn't it be very odd if the citizenship test in the 14th Amendment were broader than the citizenship test in the 1866 Civil Rights Act, particularly in the light of the fact that the 1866 Civil Rights Act was reenacted after the adoption of the 14th Amendment and remained in place until 1940?
Sure, the framers were trying to do the same thing with the language in both.
Okay, so then I think we can turn to the language of the 1866 Civil Rights Act because it's more straightforward. Subject to the jurisdiction thereof is like the puzzle wrapped in an enigma, wrapped in a mystery, but not subject to any foreign power is pretty straightforward.
Okay. All right, I can copy that, right? I can just copy that and put that in Aboriginal's title in the Marshall Court. Let me see real quick. More Aboriginal title. I know all about that though. We could do something on that too. All right, got you. I think I found something. All right.
So let me give you these examples. A boy is born here to an Iranian father who has entered the country illegally. That boy is automatically an Iranian national at birth, and he has a duty to provide military service to the Iranian government. Is he not subject to any foreign power?
Not within the meaning of the 1866 Act, Justice Alito. And that's clear from Wong Kim Ark, and it's clear from the debates. What the framers meant by the phrase not subject to any.
She said no. And she's basically what she's doing, she's calling the framers idiots. Yeah, she's saying, no, that ain't what they said. Why do you think the Alien Seditions Act was created? Why do you think, lady, that Naturalization Act was created? Why do you think the 13th and 14th Amendment was created? Why do you think they abolished slavery in the 1800s, early 1800s? Why do you think these happened? Was that to just let people just keep coming over here willy-nilly and dropping babies and still owing allegiance to the country they come from? Really? Is that what you're saying? Is that what you're saying? And you're saying it with a straight face. I could guarantee you're saying it with a straight face and probably with that weird ass smile you got on your face. Shit.
Foreign power was referring to the ambassador exception. If it meant what the government contends, basically not a subject of any foreign power, that another country considers you a jus sanguinis citizen, then lawful permanent residents, all foreign nationals.
Well, ordinary.
Hey, I was over there on the other channel. I put the link in the chat. I told everybody I was going live when I was up there talking to that little nappy-headed little boy. Yeah, I saw you typing in the chat. Yeah, I didn't even put the share out there like that this time. I was behind schedule anyway, so I was just like, "Yep, it is what it is." We still on the same thing. Appreciate you being here. Indeed, indeed, indeed. We own it. My bad. I thought you saw the link I put in the chat over there on the other channel.
The public meaning of that would certainly encompass that boy, would it not?
Justice Alito, if you think that the language of the 1866 Act was ambiguous, as Wong Kim Ark says, the shift to the language of the 14th Amendment, which is the operative text, certainly clears up any ambiguity.
What I said about a boy born to an Iranian father is true of children born here to parents who are nationals of other countries. If I'm correct, it's true to a child who's born here to Russian parents. It's true to a child who's born here to Mexican parents. They're automatically citizens or nationals of those countries and have a duty of military service. It sure seems like that makes them subject to a foreign power.
But again, Justice Alito, that would have meant that the children of Irish, Italian, and other immigrants which
Here she go. Here she go. Deflecting. But what I'm going to do is I'm going to actually use her words against her. Because if you want to bring up the Irish and Italians all those times, why were they brought over here? See, this is what they don't want to do. They don't want to open up the can of worms. This is why they're abbreviating certain things. And this is why she's trying to strong arm them. And then she said, okay, if you're going to push that way, then what about these people way back in the 1800s that was brought over here and naturalized as free white persons? What about them? But no, it changes for these other groups. Yeah, you don't want to go there with me. See, this is what she's saying. Mm-hmm. I don't know. I might like where she's going with this. Hold on. Wait a minute. Remember, they're all foreign, unless they can prove otherwise.
Wong Kim Ark refers to and the debate the framers refer to would not have been citizens either, because if the only test is whether that US-born child is considered a citizen by another country under their jus sanguinis laws, then no foreign nationals' children would be included
in all of
citizenship.
those cases, the parents could be naturalized, and then the children would be derivatively naturalized when the parents were naturalized. Wong Kim Ark, I'm sorry, the red light is on. Wong Kim Ark has a passage explaining how this court should treat dicta. And it quotes something that John Marshall said. It is well, this is quoting from Wong Kim Ark, it is well to bear in mind the oft-quoted words of Chief Justice Marshall, it is a maxim not to be disregarded, that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. If they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for a decision. So does that fall within the, what's good for the goose is good for the gander rule? That's how Wong Kim Ark treats what was said in the slaughterhouse cases. Should we apply that same rule to Wong Kim Ark itself?
Wong Kim Ark tells you what to make of the slaughterhouse dicta. It was dicta. The issue of citizenship was not at play in slaughterhouse. And in contrast, the parts of the holding, the parts of the decision that I alluded to are the controlling rule of decision. Again, we look to the English common law in construing the 14th Amendment.
Thank you, counsel. Justice Thomas, anything further, Justice Alito?
Well, just a couple more questions. So if those who framed and adopted the 14th Amendment had wanted to limit the citizenship test to just those specific groups that you concede,
What happened? Hold on. Is it done? Oh, I guess that's it. I guess that's it. Well, I think you got somewhere. Okay, so let me address this question. So it said, this is clearly about people who were deprived rights and their rights were restored. It has nothing to do with foreign nationals. Now, I need a little clarity on that, but let me just respond as I can respond. Said the general will come back and bring up black folks. Okay. Well, something happened. They like cut it off. I'm gonna go get the other one from the other guy that had it and see where it goes from there. But if I could say this, if the main thing was talking about children, and more importantly, children of women, slaves being brought over here, then it seems like this was something that was given. I don't think it went in the other direction. That's why I think Attorney Wayne was saying, well, if it doesn't matter what these Asians, because really she's focused on the Asians, and any of the new people that are now coming over here, she's like, well, what's different from now, what was happening back then when these Irish and these Italians was coming over here, right? So this is where they get into the point where you make this pass, because you already know that what went on during that time. We know what went on at that time, and we're going to tongue in cheek this thing, where people were brought over here for a specific reason. Now, right. So the orphans, Orphan Annie, all these, remember Orphan Annie? You had the Little Rascals. I don't really get in that Cabbage Patch thing. That's pseudo to me. Prove it. But we do remember that. So that's how I kind of look at it, Americanisms. But let me bring up the other one real quick. Let me just do a quick, y'all stay put. Let me just throw something in there, some little music, whatever. Let me, I'll just do it like this.
Face down in the mainstream. Like it is what it ain't, all pieces of cream. That's why some found folks face.
Cabbage equals womb. Well, I tell you, you be coming up with some doozies. All right. I got the other thing. Let's see how it ended off, because that one got cut off for some reason. I already got this guy's permission, so don't trip. Let's go. Pull it up.
Why didn't they refer specifically to those groups? Why did they adopt a general rule? They could have said all persons born or naturalized in the United States, excluding Indians not taxed, and those ineligible under common law are citizens of the United States and of the state wherein they reside. Or they could have said all persons born or naturalized in the United States, excluding Indians not taxed, and the children of foreign ambassadors or foreign invaders are citizens of the United States and of the state wherein they reside. But they didn't do that. They adopted a general rule. So what's the explanation?
I would say the Wong Kim Ark tells us with the not at play.
We ain't heard that part yet, right? Yeah, we ain't heard that one. We ain't heard that one yet. Hold on, let me go back here. Yeah, hold on a second. Yeah, let me go back here. Yeah, let me hold on a second. Yeah, let me go back here. Come back.
Rule to Wong Kim judgment in a subsequent
Not at play.
what's good for the goose is good for the judgment in a subsequent suit when the very point is presented for a decision. So does that fall within the, what's good for the goose is good for the gander rule? That's how Wong Kim Ark treats what was said in the slaughterhouse cases. Should we apply that same rule to Wong Kim Ark itself?
Wong Kim Ark tells you what to make of the slaughterhouse dicta. It was dicta. The issue of citizenship was not at play in slaughterhouse. And in contrast, the parts of the holding, the parts of the decision that I alluded to are the controlling rule of decision. Again, we look to the English common law in construing the 14th Amendment.
Thank you, Counsel. Justice Thomas, anything further, Justice Alito?
Well, just a couple more questions. So if those who
Okay, we right on time. Yep, this is where it left off at. Yep.
framed and adopted the 14th Amendment had wanted to limit the citizenship test to just those specific groups that you concede fall outside the birthright citizenship rule. Why didn't they refer specifically to those groups? Why did they adopt a general rule? They could have said all persons born or naturalized in the United States, excluding Indians not taxed, and those ineligible under common law are citizens of the United States and of the state wherein they reside. Or they could have said all persons born or naturalized in the United States, excluding Indians not taxed, and the children of foreign ambassadors or foreign invaders are citizens of the United States and of the state wherein they reside. But they didn't do that. They adopted a general rule. So what's the explanation?
I would say the Wong Kim Ark tells us what the explanation is, that the framers of the 14th Amendment, after overriding President Johnson's veto, wanted to adopt a universal rule with a closed set of exceptions. And they believed that, subject to the jurisdiction of the United States, did that. And that term does describe both the universal general rule and the common law exceptions, with the sole additional American exception for tribal Indians.
Thank you.
Justice Sotomayor?
Ms. Wang, I've not quite understood the Solicitor General's argument that lawful domicile somehow changes the U.S.'s dominion over a person or allegiance. Even in Justice Alito's examples, if your parents are Iranian, if you get lawful permanent residency here, that child still, by their laws, when it leaves the United States, must serve in the Iranian army, correct?
Well, I don't know the answer to that. What I can tell you is that under Wong Kim Ark, the court says, we don't care about problems of dual nationality. We don't look to other countries' laws in construing our 14th Amendment.
Well, it was undisputed there that Wong Kim Ark's parents owed loyalties to China, correct?
Sure, yes.
What I'm saying is, even if you become a permanent resident, you're not a U.S. citizen. So
Correct.
Your primary loyalty still remains with your citizenship country, wherever you came from.
That's right, Justice Sotomayor. I take your point now.
You understand what I'm saying? And during temporary, whether it's lawful or unlawful, temporary presence in the United States, you are subject to the U.S. laws, correct?
That's right.
I like making my podcast. I don't like making short clips of my podcast. So the AI chooses the best.
The question that the 14th Amendment asks is whether the US-born child is subject to US jurisdiction when they're born.
Meaning, are they within the U.S. territory?
Exactly, other than people covered by that closed set of exceptions.
Okay, thank you.
That's right. In other words, the government's rule, which really is looking at whether someone has a divided allegiance because they're a citizen of another country, would exclude the children of all foreign nationals. And that isn't what they're saying.
Exactly. So the only way that allegiance, lawful or unlawful, has no play in this question.
I would say that the relevance of allegiance is the relevance under the English common law rule that's embodied in the 14th Amendment. All persons born in the territory of the sovereign owe natural allegiance.
Except for the three limited exceptions.
Precisely.
Kagan?
I think I'd like to take you back to the first question that Justice Alito asked General Sauer, and it was this question of, what do we do if we think we have a new problem that didn't exist at the time of the 14th Amendment? I don't think actually that the US government argues the case this way, but let's put the US government's arguments aside and just ask something like, well, everything that you're saying would suggest an answer to the question of people who, the children of people who are temporarily in the US, but here lawfully. Is there any way that there might be a different answer with respect to the children of people who are here unlawfully because of this new problem issue that Justice Alito has raised?
No, there is no difference. And of course, the government's arguments as to people who are unauthorized immigrants in this country all runs through and hinges on their domicile requirement. The first thing I would say in response is that, once again, it's crystal clear from Wong Kim Ark and from the debates that the framers of the 14th Amendment meant to have a universal common law rule of citizenship subject to the closed set of exceptions. And we can't take the current administration's policy considerations into account to try to re-engineer and radically reinterpret the original meaning of the 14th Amendment. The second point I would make is that—
I want you guys to understand that, what's up everybody, this is Dennis Sperling. Understand that Trump has decided
that I think our history would be a little different. And I think the text, even put aside the history, which is, if the 14th Amendment—
earlier in the debates on the 1866 Act, where Senator Lawrence talks about the great case of Lynch versus Clark, where it was conclusively shown that all children born here are citizens without any regard to the political condition or allegiance of their parents. And then, of course, they discuss the children of temporary sojourn.
Which is, if the 14th Amendment used the phrase not subject to any foreign power, to give a much tougher argument. And then earlier, I think you indicated that that's what they meant, even though they didn't say it. Just want to give you a chance to unpack that, because I think that's
Sure.
If it said that, I think our history would be a little different. And I think the text, even put aside the histories, because that's speculation, the text would be quite a bit different.
Sure. So let me answer in three parts. The first is that Wong Kim Ark tells us that, the court already dealt with this and said, look, the framers were trying to do the same thing with the language of the 1866 Act. To the extent you think that the language is ambiguous or not as good, let's look at the operative text subject to the jurisdiction thereof. The second point I would make is that it's clear from the debates that the framers, in using the phrase not subject to any foreign power, were thinking about ambassadors. And I believe that Senator Wade at one point says, well, I wanted to start with the phrase, all persons born in the United States are US citizens. But then I thought, oh wait, we have these temporary visitors. In fact, the government points to this quote. He says, so there are these temporary visitors we can't make citizens, and we can't make their children citizens. That's ambassadors, and that's very clear from
So if that had been the text, your argument would be that was understood to be narrower than its text would read.
Yes.
But that's not the text, so I guess we don't need to deal with that.
Sure, and that brings me to my third point, which is you can't read not subject to any foreign power the way the government urges you to without making the children of all foreign nationals non-citizens. And that's clearly not what the framers were doing.
Justice Alito and Justice Kagan raised an interpretive question that I think is important, which is, are the exceptions, you've used the word closed many times, frozen, or do we reason by analogy to the exceptions that existed based on things that were unforeseen at the time? This comes up in the Second Amendment now, comes up in free speech law. And how do we think about whether it's possible that there could be an additional exception based on modern circumstances, reasoning by analogy to the exceptions that exist? I'm thinking in particular about the non-citizens unlawfully in the country, not the temporary part, but the non-citizens unlawfully in the country.
Sure.
Could you reason by analogy? You've used the phrase several times, I think, the fiction of extraterritoriality. And could that apply? And if not, why not?
Sure. So here, I agree with Professor Whittington, who says that the government's position here is not positing a new application of the rule, but a challenge to the rule itself. And I think that's right. We know that the 14th Amendment's rule does provide for a universal rule with a set of closed exceptions. Wong Kim Ark says so at least twice. It says in an earlier passage that the framers were not trying to introduce any new exceptions. To the contrary, they were trying to foreclose any caste-creating exceptions like the court had created in Dred Scott. The second reason we know this is that the debates themselves had the framers saying, number one, we are declaring what is already the law in this country, at least for white Americans, and we are putting any further exceptions to birthright citizenship outside the reach of any future Congress. They were very concerned about that. That's the whole impetus for the Citizenship Clause. And the third thing I would say is that that it would be contrary to the central purpose of the 14th Amendment Citizenship Clause to admit new exceptions. For all those reasons, the entire history of the Citizenship Clause is driven by the notion that we don't want to have any other exceptions.
And then relatedly, just a separation of powers point, but get your answer. I understand your point about the executive order, but Congress's authority under Section 5 of the 14th Amendment, I guess the answer you just gave means they don't have any authority to look at this, even if they passed it 435-0 in the House, 100-0 in the Senate, and said, we're carving out a new, by analogy to the existing categories, a new exception. Your point is, no, they're closed, they're frozen forever.
Correct. And the way I would put it is that the Citizenship Clause of the 14th Amendment, again, has a universal rule with a closed set of exceptions. It sets a floor. So the Congress has, under the naturalization clause, the power to expand citizenship to other people not covered by the 14th Amendment, and obviously they have in many ways, but they can't go below that floor that the Constitution sets.
I think Mr. Sauer acknowledged that, and you mentioned this in your opening, that if we agree with you on how to read Wong Kim Ark, then you win. So that could be if we did agree with you on Wong Kim Ark, that could be just a short opinion, right? That says the better reading is respondent's reading. Government doesn't ask us to overrule, affirmed.
Yes.
That's that. Then last question though, why would we address the constitutional issue? This is the last one. Why would we address the constitutional issue given your argument on the statutory? Our usual practice, as you're well aware, of course, is to resolve things on statutory grounds and not to do a constitutional ground.
Sure. I think we obviously have these two paths to a win here. We're happy to win on either or both of them. I do think it would be prudent for the court to reaffirm its decision in Wong Kim Ark, where it's a landmark decision about the definition of national citizenship in this country. I just think it would be prudent for the court to go ahead and reaffirm that. But of course, we're happy to take a win on any ground.
Thank you.
Thank you.
Justice Jackson? I'm sorry, Justice Barrett.
Serious dictation was driving me crazy, so I switched to whisper flow. Here's why I'll never go back. First off, it actually gets it right. Watch what Siri does with this. Can you share?
So I have a question about the exceptions again. So in your interchange with Justice Kavanaugh just now, you were talking about it as a closed set of exceptions, and said that way, it sounds like exceptions that people had in mind at the time of the ratification, but that were not explicit in the amendment. But I took your brief to be arguing that subject to the jurisdiction thereof is the language in the 14th Amendment that refers to those exceptions.
Yeah, you see what I'm saying? They're not talking about, I'm just letting it play. I'm just going to let it play through for the last little part. But yeah, nothing. None of this came up. This is where the Pan-Africans and really ADOS, I really haven't heard FBA really talk about slavery from that perspective. So I'm going to leave them alone for now. But this is where they really, I guarantee you, business, then your business, that they haven't even listened to the argument. I guarantee you they haven't listened to the oral argument. Guaranteed. You see where I have a problem getting through to people? Because everybody got it made up in their mind of what they want to know. And also, I think it hides the fact that they really don't know shit. And they wouldn't even know how to interpret this or dissect it anyway. You know what I'm saying? Like, these last 3 days should be getting thousands of hits right now. Just people watching it. You ain't got to hit the like button. Just watch it. Get an understanding as it's being broke down. What is it saying? What is it not saying? What are they saying? And what are they not saying? I mean, that's pretty much it.
Am I right?
That's right.
Okay.
It describes them.
It describes them. And would you say, this goes back to a question that Justice Gorsuch asked General Sauer, our relationship to the Indian tribe.
It would be prudent for the court to go ahead and reaffirm that. But of course, we're happy to take a win on any ground.
Thank you.
Thank you.
Justice Jackson? I'm sorry, Justice Barrett.
So I have a question about the exceptions again. So in your interchange with Justice Kavanaugh just now, you were talking about it as a closed set of exceptions, and said that way, it sounds like exceptions that people had in mind at the time of the ratification, but that were not explicit in the amendment. But I took your brief to be arguing that subject to the jurisdiction thereof is the language in the 14th Amendment that refers to those exceptions. Am I right?
That's right.
Okay.
It describes them.
It describes them. And would you say, this goes back to a question that Justice Gorsuch asked General Sauer, Our relationship to the Indian tribes is different today than it was at the time that the 14th Amendment was ratified. Let's put aside Section 1401. Is an tribal Indian born on a reservation today, on tribal land?
All righty. So, so she's saying 1401. So what is 1401? In regards to the relationship changing, right? So the relationship is different now. Now, it's interesting that Amy Coney Barrett has been very codified in her talking about this. And she's more codified than anybody else in regards to that. So being that she just asked a good question, a vital question, because they keep coming back to that. All right, so let's go back. Let's get it. Let me see where we at. 139.34. Okay, I'm off mute. All right, cool. 139.34. Let's go to 138.53.
And said that way, it sounds like exceptions that people had in mind at the time of the ratification, but that were not explicit in the amendment. But I took your brief to be arguing that subject to the jurisdiction thereof is the language in the 14th Amendment that refers to those exceptions. Am I right?
That's right.
Okay.
It describes them.
It describes them. And would you say, this goes back to a question that Justice Gorsuch asked General Sauer, our relationship to the Indian tribes is different today than it was at the time that the 14th Amendment was ratified. Jurisdiction of meant when you say closed set of exceptions?
I was on mute. I know I was looking at the other screen and everything. Right. So that right there is very important. Okay, so when she said by statute, and Coney Barrett is codifying her language a little bit. Now I see where she's going with it. All right, maybe I jumped the gun on her. I should have gave her a chance. But now I can hear what she's saying. Because when she pretty much set Wang up to think that she was siding with her to go in a direction that she thinks she was going to go with what she was talking about. In that same instance that Justice Coney Barrett said, oh, that's what you're trying to say. That's why she cut her off. She was like, when she tried to say the United States, providing citizenship for all tribal Indians and da-da-da-da-da-da, she was cut her off. He said, no, by statute. That was done by statute. By statute means not constitutional. That is your plenary doctrine, your trust doctrine, your dependency doctrine, how they dealt with the tribal Indians in order to subject them to and then claim some type of authority by proxy or by doctrine, which you call plenary powers. So let's see where this goes. I'm getting ahead of myself, but where are we at? 39.54. Let's go to 39.45.
Natural-born citizen under the 14th Amendment.
Under the 14th Amendment, no. Of course, Congress has provided for citizenship for all tribal members in the
By statute,
Act.
by statute. And so is that because what's subject to the jurisdiction of meant when you say closed set of exceptions, it means that the jurisdiction as it existed at the time of the 14th Amendment is still the jurisdiction today? So let me just be a little bit clear. Justice Kavanaugh asked you if we could create new categories by analogy. So there may be other sorts of people who were present here to whom this subject to the jurisdiction, in the same way that we were talking about, the bubbles around ambassadors or the soil of occupied territory or the soil of tribal land. Perhaps those new carve-outs could exist by analogy today, like if the United States carved out some portion of some state and suspended it from its jurisdiction. Wouldn't the principle still apply?
No, Justice Barrett, for two reasons. The first is, again, that there is a closed set.
But why is it closed? The language doesn't say it's closed.
Sure, we know it's closed because the very purpose of the Citizenship Clause was to foreclose new exceptions. That's clear from the debates. And I would say that the language describes a closed set as well, because you can't imagine another situation. The government's trying to make us imagine a.
Now I'm trying to figure out why she said foreclose. I'm gonna go back just a little bit. We'll go to 40. There we go.
Carve-outs could exist by analogy today, like if the United States carved out some portion of some state and suspended it from its jurisdiction. Wouldn't the principle still apply?
No, Justice Barrett, for two reasons. The first is, again, that there is a closed set.
But why is it closed? The language doesn't say it's closed.
Sure, we know it's closed because the very purpose of the Citizenship Clause was to foreclose new exceptions. That's clear from the debates. And I would say that the language describes a closed set as well, because you can't imagine another situation. The government's trying to make us imagine another situation, right? They say, look, what if Congress, in order to do an end run, in order to change the meaning of the 14th Amendment as to unauthorized immigrants' children, Congress can say, we are not going to exercise jurisdiction.
Well, not quite, because it's redefining jurisdiction. It's not quite analogous, right? Because the government's domicile theory is a little bit different than the jus soli theory, right?
Sure, that's right.
Yeah.
I'm just saying that in the second step of their argument as to undocumented immigrants, where they have to get around the fact that undocumented immigrants, by and large, are domiciled in the United States, they're trying to say, look, we're gonna manipulate the law either to define domicile or to carve out, to say, just wave a magic wand and say these babies are not subject to the jurisdiction of the United States. There's still a missing factor under that original meaning of the 14th Amendment, and that's that there is another sovereign who can exercise jurisdiction over this person, even though they're in the United States. And this gets me back to a question you asked, Justice Alito. The difference between an ordinary non-ambassador foreign national and everyone who's subject to one of those jurisdictions is that even if you take the government's argument and say a foreign national is subject to their country of nationality's jurisdiction in the United States, is actually not true. If I'm a French national in the United States, France cannot come into the United States, arrest me, and try me for a crime under French law. And that's what sets ordinary foreign nationals apart from ambassadors.
Well, no, I mean, I understand. that wasn't quite the hypothetical. I understand that. Let me just ask you, no, that's okay. Let me just ask you one last question about Indians. So I gather what you're saying is that Congress cannot expand the set of, we'll call them exceptions, right? But you're saying it can't contract them either, and that was the Indian example. So what if, again, putting aside Section 1401, what if our relationship with tribal Indians has changed so much that we would say, no, Indians really are fully subject to the jurisdiction of the United States in the way any other, natural-born citizen is? You're
Okay. Uh-oh. All right. Let's see. All right.
saying that that doesn't change the constitutional status of Indian citizenship.
Let me be clear. What I'm saying is that the meaning of the 14th Amendment is we have to go with the original public meaning. And obviously at the very time that the framers were, thinking about the 14th Amendment, at the time of ratification, that relationship between the United States and tribal nations was in flux. Right, the government has made various arguments about Congress's authority, but the way the framers thought about it and the way that Wong Kim Ark describes it is that there was a unique constitutional status unlike any other relationship between sovereigns in all the world, between the United States and the Indian tribes. And that is what gave rise to the pre-existing exclusion of Indian tribal members from US citizenship. And that's what the 14th Amendment captures.
Do you need a loan for your business? Well.
So I want to understand how you.
United States
really are fully subject.
We're going to go back. I want to hear this again. Then we're going to stop it right here.
You're saying that that doesn't change the constitutional status of Indian citizenship.
Let me be clear. What I'm saying is that the meaning of the 14th Amendment is we have to go with the original public meaning. And obviously at the very time that the framers were, thinking about the 14th Amendment, at the time of ratification, that relationship between the United States and tribal nations was in flux, right? The government has made various arguments about.
So at the time of the 14th Amendment, which is Civil War, the relationship was in flux. So that means it was bad. Now just think about it. This was supposed to be a relationship done by treaty, meaning dealing with trade and business. Trade, business, and no trespassing, and establishing jurisdiction and territory. All right? So it's in flux right now. They haven't addressed this in a long time. But see, this whole birthright citizenship, if you guys see it now, it's more than just slavery.
Congress's authority, but the way the framers thought about it and the way that Wong Kim Ark describes it is that there was a unique constitutional
of Indian citizenship.
Let me be clear. What I'm saying is that the meaning of the 14th Amendment is we have to go with the original public meaning. And obviously at the very time that the framers were, thinking about the 14th Amendment, at the time of ratification, that relationship between the United States and tribal nations was in flux, right? The government has made various arguments about Congress's authority, but the way the framers thought about it and the way that Wong Kim Ark describes it is that there was a unique constitutional status, unlike any other relationship between sovereigns in all the world, between the United States and the Indian tribes.
Now, in my debate, I mentioned plenary powers, and that was dealing with Congress and the Supreme Court, how they were manipulating the law or misrepresenting material facts on its face in order to gain an advantage. Now, if you heard that correctly, she put it very clearly that the relationship between the United States and the tribal nations here in America were unlike no other relationship the United States had with any other considered to be sovereign nation in the world. And during the 14th Amendment, we're getting to a summary of what the Civil War was about, was the fact that they wanted out. They was feeling too big for their britches. And then they wanted to go ahead and get out of the agreement. They knew they couldn't get out of the agreement because at the time, the tribal nations was the strongest in the world because they had the strongest military in the world. It's the same military that you see today. And if, by what she said, that the relationship that the United States had with the tribal nations here in America was unlike no other, that means the tribal nations had to be stronger and more powerful than any other nations, and most likely colonized by the tribal nations with companies and all the trades and everything right there. Since for the fact it's been mentioned a bunch of times that almost all the crops that are that exist all over the world originate in America. So that was good. Very good. Clip that.
And that is what gave rise to the pre-existing exclusion of Indian tribal members from US citizenship. And that's what the 14th Amendment captures.
Check. Cool. That's a check. The 14th Amendment captures one thing. Highlights one thing. That is, regardless of what's going on, the continuing relationship is that we will never be subject to the United States. The tribal nations and the people would never be subject to the jurisdiction of the United States. But we will now give people the opportunity to start doing business with the United States within the United States. Come and work, do whatever needs to be done, so on and so forth, the expansion of things. Yeah, we'll give you some territory over here. You can do that, so on and so forth, so we can keep it cool. This is why you have a lot of these new treaties that's being established in the 1866 through 1868. Now, this is my own thesis, hypothesis, my opinion. If you have these treaties that are then established, meaning that you have all these different immigrants coming in, hey, we need to up our ante on people, you know what I'm saying? We need to up our ante. So that way we can stay relevant and stay functional. Because if it doesn't happen, the tribal nations got to look out for their own interests. What is going to be the best thing? We really can't, there's really no other entity or company or whatever you want to call it, what the United States is, that we can trust in doing business with. We got to mess with them. We got to. If we don't, we bring somebody else in, it's going to get real bad. So we'll make a deal. We're going to allot you some land so you can continue your businesses in all these places. And we'll allow these new citizens to come over. So what you're going to have to do is you're going to have to create some amendments to your Bill of Rights to include these people so that they can be properly here, properly vetted, and that will up your membership into the United States, right, to join the union. On top of that, some of the states that are now incorporated today are those states which are carved in a certain specific area that will be able to up your membership or your citizenship, you know, under the new circumstances. Now, this is my hypothesis, my thesis, my opinion. It's common sense, though. But it's going to be hard to be common sense if you think that the tribal nations here were a bunch of cloth wearing, feather wearing, bonfire, dancing around with nothing but trees and dirt around them. It'd be hard for you to fathom that if that's what you see. Tonto and all that, that's what you see. If you see buffalo soldiers, if you see some of the main things that, we know brothers was doing back then, the style of everything, then it might make sense. If you equate the inventions of everything, the creations, the pyramids, the cities, the towns, the bridges, the state capitals, all the buildings and stuff that you see, these colossal buildings that they say was made in 2 years. then you'd be like, okay, that makes sense. Yeah, I think they might be good enough to be engineers and have ingenuity and, create engines. And yeah, maybe.
Justice Jackson?
So I want to.
We're going to leave it right there. We're going to end it right there on that one. We're going to end it on that one. Now, what I want to do real quick is I want to just go over some of these terms, and then we'll be able to. All right, what's up, nonetheless? The word capture was used for a specific reason. Okay. I'm going to go ahead and look up. We're going to go, I'm going to just share my whole screen. Entire screen. That's what we're going to do. And I'm just going to fly through this. I'm not going to spend a whole lot of time on it. Just going to fly through it. All right. So the 14th Amendment, let's get to it. Let's get straight to the 14th Amendment. All right. Let's get to the 14th Amendment. Now, this is the 14th Amendment, Constitution of the United States. All right. This is Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof. Let me make sure I'm off mute. I am. Are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the law. Now, what is the key word here? Persons. Subject to the jurisdiction. Born or naturalized. All right. Section 2, representatives shall be apportioned among the several states according to their respective numbers, counting the whole numbers of persons in each state, excluding Indians, not taxed. But when the right to vote at any election for the choice of electors for president, vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime. The basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Now, we're going to go to Article 1, Section 2, Clause 3. Now, representatives and direct taxes shall be apportioned among the several states. What does this say? Representatives shall be apportioned among the several states. Representatives and direct taxes shall be apportioned among the several states. Representatives shall be apportioned among the several states according to their respective numbers. See, they say direct taxes, so direct taxes is out. Okay, this says, which shall be determined by adding to the whole number of free persons. This says number of persons, including those bound to service for a term of years and excluding Indians not taxed, comma, 3/5 of all other persons. Now, 3/5 is somebody that has not met the age of majority. That means they're not adults, they're children. Children can't be taxed. This says excluding any is not taxed. 3/5 persons is out. But when the right to vote at any election, right? That language. And it says, this says the actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States and within every subsequent term of 10 years in such manner as they shall by law direct. Down here, it says, these are the states, and these are what you consider your 13 colonies that you will know of today. This doesn't have that. This just talks about voting and representatives. So the language has changed quite a bit. But what doesn't change? Excluding Indians not taxed. Persons. All right. All right. So they just have persons here, but then they have free persons in the beginning. So Article 1, Section 2, Clause 3 has free persons. Enumeration is out of there. All right. So we know that. Let's go to the next one. She said, excluding Section 1401, which is the Immigration and Nationality Act, defines who is a U.S. citizen at birth, while the 14th Amendment guarantees citizenship rights and equal protection under the law. The relationship between these legal frameworks and Native Americans has evolved, particularly with the Indian Citizenship Act of 1924, which granted U.S. citizenship to Native Americans, although many still faced barriers to voting and representation. This also shows you who the Indians are too as well. So why couldn't they vote? Who was campaigning for the voter rights bill? Who was campaigning for proper representation? So-called black people. All right. Let's see what's next. Okay, we got the Aboriginal title, isn't it? Brought this up, this Aboriginal title in the Marshall Court. Let's see what's going on here. Marshall Court issued some of the earliest, most influential opinions by the Supreme Court of the United States on the status of Aboriginal title in the United States. Several of them written by Chief Justice John Marshall. This is what you consider to be that Marshall trilogy, right? Isn't it? Yeah. However, without accepting the remarks of the court on an Aboriginal title during this period are dicta, right? And they kept mentioning that. In legal writing, a dictum is a statement made by a court. It may or may not be binding as a precedent. So this is why they're using the word dicta. Only one indigenous litigant ever appeared before the Marshall Court, and there Marshall dismissed the case for lack of original jurisdiction. Bingo. All right, we rocking with that. All right, so temporary sojourners and birthright citizenship. Type that in there. Let's see what that is. We're going straight AI. We're going quick. We don't need to do the extras. So the concept of temporary sojourners has been discussed in relation to birthright citizenship, with historical debates indicating that citizenship would extend to their children, regardless of the parents' legal status or intent to stay temporarily. 14th Amendment's birthright citizenship clause has been interpreted to include children born on U.S. soil, even to those with temporary or uncertain immigration status. But we already know that this is This is false, because I just read you the 14th Amendment, and it mirrors, and it's an amendment to Article 1, Section 2, Clause 3. It doesn't mention birthright citizenship. It doesn't mention it. It talks about the number of, counting the whole number of, see, before they said enumerating, now they said counting the whole number of persons in each state, excluding any not taxable, when the right to vote at any election for the choice of electors, so on and so forth, so on and so forth, so on and so forth, or the members of legislation thereof, is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, or any way abridged, except for participation in rebellion. The basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. So they're setting a standard on age limit. Nothing at this point in time is talking about birthright citizenship. Nothing. 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 All right, so boom. All right, boom. So that holds no weight. Okay, so that's a Marshall Trilogy of Nations. All right, so we got that. That's an abstract. We'll look into that. That's the case law that they were talking about. I'm going to look into that. Okay, so this is Indian tribal exception in the birthright citizenship. So the Indian tribal exception in birthright citizenship returned to the historical understanding that Native Americans born into tribes were not considered U.S. citizens under the 14th Amendment at the time it was ratified in 1868. This exclusion was later addressed by the Indian Citizenship Act of 1924. This is why Justice Comey Barrett kept saying by statute, by statute, by statute. This is the statute. All right. Well, we'll get back to that. Okay, so the Alien Seditions Act. The Alien Seditions Act, and then we're going to be done. I'm going to do this in the Naturalization Act, then we're going to go to free white persons and a Black's Law, and then we're done. The Alien Seditions Act of 1798 were 4 U.S. statutes that restricted naturalization, empowered the President of the United States to detain and deport foreigners, and criminalize false or malicious statements against the federal government. The laws were endorsed by the Federalist Party led by President John Adams. National security grounds in response to later stages of the French Revolution and ongoing disputes with the French revolutionary government, which had culminated in naval skirmishes. The prosecution of American journalists under the Sedition Act rallied public support for the opposition, led by Thomas Jefferson, who defeated Adams in the presidential election of 1800. So this is the Alien Seditions Act of 1798. Now you have the Naturalization Act of 1790. Now we know 1789 they supposed to have started. 1790 also was supposed to be the first federal census. So it says the Naturalization Act of 1790, 1 Stat 103, March 26, 1790. See, all great things happen in March. How about that? Was a law of the United States Congress that set the first uniform rules for the granting of United States citizenship by naturalization. Naturalization is the legal act or process by which a non-national of a country acquires the nationality of that country after birth. The definition of naturalization by International Organization for Migration of the United Nations excludes citizenship, so on and so forth. You see how they changed the language? That's not it. They said the nationality of that country after birth. Now, we could try to figure out what birth means. If you get a birth certificate or a certificate of live birth, yeah. But a lot of people that come over here that's not born here do get a birth certificate. Once they become naturalized, they do get a birth certificate. So that birth on this earth is different from being a birth in the United States. We're just going to use the United States. The law limited to free white persons of good character. The law limited naturalization to free white persons. The legal and social structures that define white Americans and distinguish them from persons who are not considered white by the government and society have varied throughout the history of the United States. Race is defined as a social and political category within society based on hierarchy or hierarchical means, whatever it might say after that. I'm not going in there. Now we know what white means. It's a racial, social, and political category. All right? Don't take it nowhere outside of that, people. It's right there. All right? Now, let's go over here. We're going to go to Black's Law Fourth. And we're going to go to free white persons. Now, this is free white persons as amended by the Act July 14, 1870. So this is 1870. This is the 1790. So it says, let me see if I can blow it up just a little bit more. Yep, I can. It says, referred to in Naturalization Act, as amended by Act July 14, 1870, has meaning naturally, giving to it when first used, 1 Stat 103, like I read, meaning all persons belonging to the European races, then commonly counted as white. So in Stat 103, white persons, or the Naturalization Act, was only geared to what they considered to be belonging to the European races, then commonly counted as white, and their descendants, including such descendants in other countries to which they immigrated. Right, with E. So that means they started somewhere, they end up moving. So that means it traveled with them. Now, it includes, okay, outside of the first initial understanding of what the European races were, it includes all European Jews. Those European Jews were considered to be Sephardic, some sort, but let's just keep it where it's at. European Jews, more or less intermix with. So these European Jews, more or less intermix with peoples of Celtic, Scandinavian, Teutonic, Iberian, Latin, Greek, and Slavic descent. It includes Magyars, Lapps, and Finns, and the Basque and Albanians. It includes the mixed Latin, Celtic, Iberian, and Moorish inhabitants of Spain and Portugal. So those are your inhabitants of Spain and Portugal. 1870. up to 1870. Latin, Celtic, Iberian, right? You have the Latin. Where is the Latinos? Of Toledo, Spain. You have the Celtic Iberians, right? You got the Celts. And Iberians, which is in Spain and Portugal. And you have Moorish inhabitants of Spain and Portugal. All right? The mixed Greek, Latin, Phoenician, and North African inhabitants of Sicily. And the mixed Slav and Tartar inhabitants of South Russia. It does not mean Caucasian race, Aryan race, free white persons, right? We're dealing with free white persons. Now, who this does not pertain to, Caucasian race, Aryan race, or Indo-European races, nor the mixed Indo-European Dravidian, Semitic, and Mongolian peoples who inhabit Persia. A Syrian of Asiatic birth and descent will not be entitled to become a naturalized citizen of the United States as being a free white person. Here's your case law. Then down here it says, nor a native-born Filipino, native of India, who belong to the Hindu race. Correct. Ram Samras versus United States. Here is your is and who is your ain't naturalized citizens. Got it? Now, under the circumstances, just want to show that so you guys can get that picture. All right? So you can get that picture, what you consider to be white and what it was during that time. All right, so we're going to leave it right there. We're not going to do any panel talk right now. Like you hear, I'm getting phone calls, so I got to handle that business. But this was good stuff. I always appreciate the participation. To everybody, what's up, Rod? Got it a little late. It's all good. Business, appreciate all the assistance in there. Oh, there you go. There you go. What's up, Firekeeper? Nonetheless, on your business. Rich. Everybody else that was listening that didn't chime in, it's all good. What I'm going to do is, hey, man, we just going to shut him down. All right. No exit. Well, let me go ahead and put some exit music on. But yeah, that's where we're at right there. So we're getting a clear idea. Hopefully we're getting a clear idea of what the history and what history is about versus what actually the law states and what has actually been done. So shout out to this new administration that's been forcing the hand and been declassifying a lot of information so we can get access to it and we can make up our own mind. I don't know, is this? I don't know if the Chinese have their own police. I do not know. I know they was trying to do something. I think that was where they was trying to get with that Asian hate crime bill to create their own law enforcement. I don't think that went through.